Okay, I'd like to call the meeting to order. I want to welcome everybody. Is there anybody new? I think we're all the same. Everybody knows everybody, right? Grant, you've been on here before, right? Okay. So our guest speaker today is Debbie Chilson from the Eviction Center, and she's going to go to a PowerPoint, so she will be sharing that with us. And welcome, Deborah.
Thank you. All right. Well, we'll get started. Good morning, everybody, and thank you for having me. Again, my name is Debbie Chilson. I work for a company called the Eviction Center. I have a PowerPoint presentation. I'm going to share some slides. Okay, right here, share. Okay, so, Sylvia will have the PowerPoint presentation available for anybody that wants a copy of these slides. So the Eviction Center, I've been with the company for about almost 9 years now. We are an unlawful detainer assistant company. We are not attorneys and we're not a law office, so we can't give legal advice, but we do urge you to, if you need legal advice, to seek a reputable attorney in the area of law that you need advice in. So, yeah, let me see. How is this going to work? Page up, page down. I'm trying to do my pages here. You know, I took a Zoom class. PowerPoint, okay. I'm doing this. Oh, here we go. Okay, it worked. Sorry. All right, so we have 3 offices. We have a remote office in Redlands. We have our main office in Beaumont, and I work out of the Hemet office. Okay, and again, I went through that a legal disclaimer that the materials provided in today's presentation are for informational purposes only and not for providing legal advice. What we do is mostly evictions. We also do some small claims, judgment enforcement services, wage garnishments, abstracts, bank levies, tenant screening services, rental placement services. On the eviction side, we do preparation of all notices. We have our own process servers. We do residential evictions, commercial evictions, after foreclosure evictions, forcible detainers, and assistance with security deposit dispositions. Okay, so what I want to talk about is our services, but mostly what I want to talk about is what's happening in the eviction realm lately because of COVID. We were closed down for several months because of the eviction moratoriums that were in place. But I tried to keep in contact with all of our clients on a weekly basis, answering phone calls and emails. September 1st, Governor Newsom signed new legislation that actually he signed it on August 31st. It went into effect September 1st that outlines how evictions can be done moving forward. The law is called Assembly Bill 3088, the COVID-19 Tenant Relief Act of 2020. Okay. What it is, it was urgency measure effective September 1st, provides new protections for tenants that cannot pay the rent. And so it's mostly tenant rights oriented. It really is not a good thing for landlords. Landlords now have to jump through more hoops to get rent or to do evictions. Okay, there's no more 3-day notices like before. It's a 15-day notice to pay rent or quit. And there's very specific 15-day notices depending on what months of rent are due. So the new legislation outlines 2 different time periods. There's rent owed between March of 2020 and August of 2020, and that's called the protected time period. Then there's rent owed between September 2020 and January 2021, and that's considered the transitional time period. There are 2 very different specific 15-day notices that you have to serve if you have a non-paying tenant. That 15-day notice is 5 to 6 pages long. There's 2 pages attached to it advising the tenants of their rights as to COVID, as well as a blank declaration provided to the tenant that they can return to the landlord or property manager within the 15 days if they're going to claim a COVID-19 hardship. All of the rent owed between March and August, the protected time period, that is converted to a civil debt. So you'll never be able to evict off of non-payment of those monies. All of the rent owed between September and January is during the transitional period. If you were to serve a 15-day notice to pay, rent, or quit for those months, and the tenant sent back the declaration of hardship, then it's a 2-part process required of the tenant. They're also committing to paying 25% of the rent owed for that time period. And the law stated that it was due by January 31st. We're coming to the end. We're almost at January 31st. We're in January now, January 13th. So it's our thinking, we don't have any directives on this, but if you were to serve a 15-day notice today, it's going to expire after January 31st and into the first few days of February. So the 25% is no longer due January 31st. It would due at the end of the notice period, the 15 days. Also, the 15 days is business days. You cannot count weekends and you cannot count judicial holidays. And Monday, as a matter of fact, January 18th is a judicial holiday. So you can't count that day when calculating the 15 days. Okay. If you don't get back the declaration and you don't get back 25% by the end of the notice period, then you can file an eviction. Now, this law was set to expire, or is set to expire, January 31st. But we have, we're seeing in different news articles from the CAA that the legislation up in Sacramento is currently writing new laws, and they will more than likely extend the CITRA, or the COVID-19 Tenant Relief Act, AB 3088. They will extend it, if not a few months into 2021, possibly till the end of 2021. And I'm sure they're going to come out with new legislation with due dates of when the 25% will be due, so on and so forth. Okay, but we don't know yet. We probably won't know until we're almost at January 31st. So I have a lot of people asking me, what do you think? You know, is it going to be extended? Is it not? And I do believe, in my opinion, it will be extended because we are still in a pandemic. There's still shutdowns. There's still the state of emergency has not been lifted. So I do believe it's going to be extended. I just don't know how long or what the terms will be. They may change some of the terms. We don't know until we actually see it come down, you know, and signed into law. Okay. So there's mandatory informational notices that were required to be served. And if a tenant had one or more rental payments past due during the protected time period, March to August, the landlord was required to serve this notice on the screen. I just asked the attorney this morning, I confirmed with him that, okay, what if you didn't know? And there was rent due and you didn't do anything because you didn't think you could do anything. Well, you could still serve this notice and you'd be in compliance with the law. Okay. So the next screen, some forms that you need to use to comply with the 15-day notice requirement are listed here. These forms are from the CAA if you have an account with them. If you don't, I urge you to sign up with the CAA, California Apartment Association. It's CAA.org, I believe. But they are probably the #1 source that we use for information on landlord-tenant law. And they're the ones that are up on it the soonest. And they have their own attorneys that represent landlords up in Sacramento to lobby against some of the restrictions. Now, one of the things I also wanted to touch on is before COVID hit, we had a new law that came into play, Assembly Bill 1482, the TPA, or Tenant Protection Act. That law was addressing rent caps and just cause evictions on certain properties. And before COVID, certain properties were exempt from rent caps or just cause evictions. However, when AB 3088 came into play, there was a provision in AB 3088 that stated that now all properties are subject to AB 1482. So that means all properties are subject to rent caps and just cause evictions. Just cause evictions means if you were to serve a termination notice, you have to have a reason to serve that termination notice. And AB 3088 actually goes into detail as to specific reasons that are allowed by landlords to terminate a tenancy. Okay. AB 1482, which was effective January 2020, also stated that if you had a property that was exempt, and exempt properties were properties that were privately owned, single family homes that were separately alienable from any other property. You know, they had their own assessor's parcel number, things like that. Multiple family units like apartments were not exempt, or anything owned by a corporation was not exempt. Okay, real quick, but what you were required, AB 1482 required that if you did have a property that was exempt, you needed to serve the exemption notice no later than July 1st. And a lot of my clients, we made them aware of that, and they did that. Okay. Well, it also stated that any new rentals that were started July 1st or later, you needed to have a specific addendum attached to your rental contract. And that addendum is it's in the CAR forms, it's the rent cap and just cause addendum. And that needed to become part of your rental packet. Those are available through CAR. Okay. There's a couple other forms. There was the Fair Housing and Discrimination Advisory that is also required, as well as there's a new coronavirus addendum or amendment that's required. Now, if you had a property that you were managing that was in existence prior, you know, the rental agreement was in existence prior to July 1st, and you did not send that exemption notice, then it's recommended that you have the tenant sign the addendum now, and you make it part of your rental contract packet. Okay, so I just wanted to get that out there, make you aware of that for those of you that are property managers. Okay. All right. So the next slide, pre-COVID evictions were really easy compared to the way they are now. You would start the eviction process, you'd file the unlawful detainer summons and complaint with the court after serving either a simple 3-day notice to pay rent or quit, or a 30-day or 60-day termination notice. You didn't have to have cause. Then the tenants were served. If they didn't answer, you got a default judgment for possession only. If they did answer, then or file a response, we would set a court trial. You'd go to court, you'd get your judgment, and it wasn't so restrictive. Now evictions are much more difficult. Okay, first of all, you have to serve that 15-day notice to pay rent or quit. If you get the declaration back and it's for rent owed between March and August, you can't file the eviction. If you get the declaration back and it's for rent owed between September and January, and if you get the declaration back and you don't get paid the 25%, then you can file the eviction. If you just get the 25% money rent owed, but no declaration, we're recommending not to file the eviction, because if you do, just because you didn't get that hardship declaration back, but you got your 25% rent, and it goes to trial, the judge is more than likely going to say, well, you got the 25% rent that's entitled to you. I'm going to dismiss your case, more than likely. Additionally, we've been told that for those that didn't get the declaration and they filed the evictions already, say in September and October, and it's based on a non-payment of rent issue, a 15-day notice, no declaration returned, eviction filed. If it goes to trial and the tenant shows up at trial with his declaration in hand or submits it to the court late, there's something called an oops motion. That's what, more commonly referred to amongst landlord attorneys or all attorneys. And it basically states that, well, through inadvertence or neglect, I forgot or I didn't know. Well, the judges are going to be very lenient on tenants, as they are lenient on attorneys who use this motion, and they're going to accept a declaration late and dismiss your case. So that's a risk you take. Okay. The slide that's on the screen now kind of goes through the process of starting the eviction. If it's based off of a 15-day notice to pay rent or quit. Okay. Here's the next slide is a sample calendar to calculate the time period when you serve a 15-day notice to pay rent or quit. Okay, again, you can't count weekends and you cannot count court holidays. Okay, so it's really more like 3 weeks or maybe sometimes a little bit longer depending on the holidays in the month. Okay, now the next screen is a 3-day quit notice, and this is used. We have it on here. I'm not sure if it's even applicable anymore because HUD, the housing department, declared that the crime-free program is discriminatory. So that's a question that we need to bring up with attorneys. I know that I used to speak at the crime-free programs that used to be in Hemet and the other cities in the Riverside County and San Bernardino County. But because now it's been declared discriminatory, I don't think we're going to do crime-free anymore. I have asked Mr. Wyndham when this news first came out, what about those tenants that already signed it? He said you should be able to still enforce it. But I think we need to get some more legal advice on this as to the risks involved if you were to file an eviction based on a 3-day quit notice for violation of a crime-free lease addendum. But this is still in our program, so I wanted to bring that up. Okay, so there's 3 ways that we serve a summons and complaint for eviction. Number 1 is personal service. The process server goes out to the property. If the named tenants are there, we hand them the paperwork. That's personal service. They have 5 business days to file a response with the court. That has not changed. Substituted service. That can only be done after we've made 2 attempts at personal service and have not been able to be successful. Substituted service is done when somebody over the age of 18 answers the door and we hand the paperwork to that person. Then it's a 2-step service. We also mail copies by first-class mail. Then there's posting and mailing. For a summons and complaint, the legal paperwork, when after 3 to 4 attempts, we cannot get anybody to answer the door, or maybe there's a gate, we can't get to the front door, then we have to apply to the court for what's called a posting order, an application to post. The judge signs it, we get it back, and then we can go out and we can serve the summons and complaint by posting it on the door or posting it on a gate and mailing by certified mail. That's the only time you have to do certified mail according to the civil code. Okay. And here's some samples, same paperwork that we use to get a posting order from the court. Okay. And eviction process, some do's and don'ts. Real simple. You don't turn off the resident's utilities. Do not file your unlawful detainer prematurely. Do not accept rent after you file your eviction. Okay. Things to do after a lockout. If you have an eviction lockout and the tenants still have personal possessions in the property, You have to keep their stuff safe for an additional 15 days and allow the tenant an opportunity to make arrangements with the landlord, the owner, or property manager to come back and get their things. And that's at the convenience of the owner, landlord, property manager. Okay. And then whatever's left, if it's less than $700 garage sale value, you can get rid of it. Okay. Also, remember that you have to do your security deposit disposition after an eviction or after any move out to deduct any monies that may be owed, any past due rent, any damages over and above normal wear and tear of the property, and that must be done within 21 days after getting possession of the property back. Okay. So then here's a screenshot of what it's just an advisory, what's normal wear and tear or ordinary wear and tear, landlord's responsibility, as opposed to excessive damage or filth, which is the tenant's responsibility. Okay. And then our final slide, join your local crime-free multi-housing program, which we don't have anymore because HUD declared it discriminatory. Join CAA. Attend at least one fair housing seminar. You can always call our office. And again, the beginning slide had our office phone numbers on it. And I see some chat. Share window's closed. But let me try to bring that up again. For our contact information right there. So a couple other things I wanted to go over that I skipped for just cause evictions. Let me see. Where's my share screen? There we go. There we go. Share. Okay. So something that I skipped over a little bit with the serving of termination notices. So if you just want to terminate the tenancy, it's very restrictive now. If the tenant has been there for less than 1 year and you're on a month-to-month contract, you can still serve a 30-day notice, but you have to have cause. You have to have a reason, and that reason must fall within Assembly Bill 3088. Okay. 3 main reasons are number 1, the owner is selling the property, but before you serve that notice, you want to make sure that you have a buyer in place with a signed purchase agreement. And that buyer is somebody that's going to be owner occupying the property. Okay, that's with both the 30-day or the 60-day notice. 60-day notice is used when a tenant's been in the property longer than 1 year. Okay, reason number 2 to terminate a tenancy. The owner is removing the property from the rental market because either the owner themselves or an immediate family member of the owner needs the property to move into. That's reason number 2. Reason number 3 is you're terminating the tenancy because the property is in such bad shape that it needs to be demolished or substantially rehabbed to the point that the owner is being required to comply with city, state, county statutes, codes, or ordinances. Basically, there's habitability issues exist, and the tenant needs to move out so that you can do that demolition or substantial rehabilitation of the property. So those are the 3 main reasons that you must use if you're going to terminate a tenancy. There's a few others that you need to discuss with a lawyer if you can use those. One of them is if you're selling the property. Actually, I have the list right here. Right here. Regardless of how long they've been in the property, you can give a 30-day notice if these 6 conditions exist. Number 1, the landlord's entered into a contract to sell the premises to a natural person, not a corporation, not an investor. Number 2, purchaser intends to reside in the premises for at least 1 year following the termination of tenancy. Again, owner occupied. 3, landlord has established an escrow with an escrow company. 4, escrow has been opened 120 or fewer days prior to delivery of the notice. 5, title to the premises is separately alienable. Can't be a duplex, triplex, multiple unit. It has to be like a single family home or condo. And 6, tenant has not previously been given a notice of termination of tenancy. If you have those 6 reasons exist, and you're on a month-to-month contract, regardless of how long they've been in the property, you can give a 30-day notice to terminate tenancy. Okay, so I wanted to go over that. There's also a few other reasons that you can start evictions. We've done a couple of them. We're in process right now. If you have a serious breach of the contract, even unauthorized pets, unauthorized occupants, things like that, and you could still serve a 3-day covenants notice for that breach. And then after 3 days, if the tenant does not comply with the covenants notice, then you can serve a 3-day quit notice. It's not the same 3-day quit notice for the crime-free lease addendum. It's a specific 3-day quit notice for non-compliance. It's actually part of AB 1482. And you could serve that 3-day quit notice. If they don't move out, then you can file an eviction off of that. And those I'm seeing are pretty strong cases. So that's what's going on in the eviction world right now. I don't know if anybody has any questions. You can unmute and ask questions if that's okay, or in the chat. I can open up the chat.
Actually, Deborah, on what you had just stated, I do have one eviction in process with Mr. Wyndham based on a covenant. And I don't serve 2 different 3-day notices. He has me serve a 3-day notice to perform covenant or quit. So it's not, are you familiar with that?
I would check with an attorney on that. I can't guarantee, I don't know if that case will be successful, because AB 1482 required the 2 notices, the 3-day covenants and the 3-day quit for non-compliance.
Because the eviction is through Mr. Wyndham.
Oh, really? Okay,
Yes.
I'll check with him on that. Yeah, maybe there was a 3-day quit notice served. I don't know.
It's a 3-day notice to perform covenant or quit. It's just kind of both.
Okay, I'll have to check with him.
Okay.
Because that's not my understanding, but I'll check with him on that.
Yeah, I'm really curious to find out the answer on that one.
Okay, alrighty. If you email me at the bottom, email evicto3@aol.com to remind me, and then I will print out the email and I'll check with him on that and get back to you.
Great, thank you.
Okay. So is there any other questions from anybody?
I have a question. So basically, you're saying I have to have a buyer already in place, or can I have a listing agreement and then you can give the tenants notice? Like if they've been there over a year, you give 60-day notice stating that you're selling the house. They're on a month-to-month now, and just stating that you're putting it on the market. Can you do that, or do you have to have a?
No, you have to, before you serve the notice to terminate, you must have a buyer in place with a signed purchase agreement must be dated prior to the date of the notice. And that buyer has to be somebody that's going to be owner occupying. If that's.
But isn't it give them notice saying that you're putting the house on the market?
No, that's not good. That doesn't comply with 1482 or 3088.
Okay. All right. You can't give them you can't. So if they're not paying rent, can you give them notice, 60-day notice for them to leave, or you can't do that?
No, you have to use one of those reasons.
So Sandy, that's kind of very similar to the case that I have right now. And the only way you can still file if the owner intends to move in and the tenant is not paying, but the owner said, fine, we'll move into the property to get this guy out.
Yeah. So that would be a different notice. There's actually in the CAA, there's a specific termination notice where it talks about owner move-in.
Okay, but if the owner is not moving in, then you can't get them out.
You cannot.
You have to advertise it for sale and actually have a buyer before.
Yes.
And the buyer has to owner occupy.
Yes.
Yes, yes, and that buyer, yes, I understand that buyer's owner occupied. Okay, so basically I can market it though. And
Oh, yeah, there's not against the law to put it on the market. And then I might add that if you do have a rental that you put on the market for sale, that you serve the CAR form notice of sale and right of entry. We have an eviction going right now where they put the house on the market. They served a notice of sale and right of entry. They served a 24-hour notice to enter. The tenant refused. We served a 3-day covenants notice for, I believe it's on the car rental agreements. It might be paragraph 17, which they breached because they didn't allow entry to exhibit the property to inspectors or prospective buyers. So we served that covenants notice. And then after 3 days, we served or we didn't, but the agent served another 24-hour notice. This case, the agent went above and beyond. They served another 24-hour notice to try to comply with the first 3-day covenants. The tenant did not allow entry. So we did a 3-day covenants notice again, number 2. Waited 3 days, served another 24-hour notice to see if they would comply with the second covenants notice. She did not comply. We did it 3 times, 3 covenants notices. This should be a pretty strong case. And then finally did the 3-day quit for not complying with 3 previous covenants notices. She didn't move, we filed the eviction. I couldn't get her served because she has a gate. You can't even get to the front door. So I had to get a posting order. And I just served that eviction a few days ago, posting the summons and complaint on the gate. So we'll see what happens if she responds. We fully expect her to respond. So, any other questions from anybody? Everybody's muted. I don't hear anything. So let me add one last thing. Our company is offering to any realtors or any of you that if you want a one-on-one Zoom presentation with maybe all of what I said today, plus anything maybe in more detail, we'll offer that to you free of charge. Also, please, if you have any questions, my contact information is on the screen. Give me a call. And we'll try to answer whatever questions you have or discuss your eviction needs.
Thank you, Deborah. That was really informative. And Sandy, I did give on one of my own houses, I did give a 90-day, they've been there forever, gave a 90-day just using the CAR form that I was going to put it on the market. She asked for another month's time because her husband was ill. And so I went ahead and gave that to her, but she did vacate the property just as I was putting a tenant getting, or not a tenant, just a buyer, getting a buyer ready for the property. So, I mean, you can always try the old fashioned way. You just aren't going to be able to force the issue.
Yeah, exactly.
Sandy, another way that has been sort of successful for me was I actually had an owner that lost her job due to the pandemic. So she's under financial hardship and she's, Michelle, I need to sell the property. Well, it happens to be in a senior 55 plus community and the seniors, the tenants are very elderly and they have health issues. And I'm like, good luck letting them see anybody or letting anybody into the house during the pandemic. So what we did is, I mean, this is not optimal or I mean, we kind of did what we had to do for the owner because she's in a financial hardship, but we raised the rent $300 and we had to give the 90-day notice because it was over the 10%. But the tenant was like, wow, we can't stay here. We're going to have to move.
Okay.
So that's another thought. I mean, they haven't moved yet, but, and I tried to explain to the tenant that the owner is under financial hardship. Otherwise she would have never done this. And they actually were very nice about it and understood. They're like, we get it. Everybody's struggling over this pandemic. So that's just a thought. I mean, normally I wouldn't do that to people, but if you really want a tenant out.
That's,
I would say that you take the chance of
yeah, that's,
saying we're not going to pay anything then, and still nothing you can do about it.
Mhm.
That's the risk you take of bumping the rent up like that to encourage them to move out is.
Well, they
Yeah,
actually,
that's
it
what I'm
became
saying.
effective January 1st and they actually did pay it. They're having trouble finding another rental. They were way, way below market value because they take pristine care of the house. And the owner had no intention of ever kicking them out until she had financial hardship. So, I mean, she feels horrible about it. I mean, we all feel horrible about it, but they're paying it in the meantime until they can find somewhere else. They're looking like Sun City where the rents are cheaper. But their problem is they can't find anybody to show it. They said people are wanting to rent the property sight unseen, like because of the pandemic, they're not willing to show. And I'm like, wow. And they're not willing to rent sight unseen. So they're trying to find somebody, a realtor that's willing to show the property.
I was going through the chat and I wanted to know if it's okay if I answer a couple questions. There was a question
right
from
ahead.
Grant. I know I should have had it up earlier.
Yeah, go ahead.
To Grant, if you served the exemption notices before, do you need to serve a new notice? I don't believe so. If you've served it, then you're good to go. And then who considers the $700 value? The owner. It's garage sale value. Okay, yard sale value. So if they leave an old dirty couch in the property, how much are you going to get for it in a garage sale? 20 bucks. Okay. So it's the owner, and you can always go to the Salvation Army website or Goodwill website to check on, what values might be. Okay. The contact info for CAA, I believe it's CAA.org. Okay. You can just Google California Apartment Association and it'll come up with that. And Robin, Happy New Year.
Happy New Year. I need to talk to you after the Zoom.
Okay.
Thank you.
Okay. All right. And I think that's it. Is there
Any other questions? Unmute yourself if you have more questions.
Yes, please.
I have a question. I wanted to know, will we get a copy of the
Slideshow?
PowerPoint?
You can get a copy from Sylvia. I sent her a link. I sent her a copy of it, so she can get you a copy.
Awesome, thank you.
Mhm.
Okay, thank you very much, Deborah. If you'll quit sharing your screen, then Sylvia
Yeah.
can go ahead and put our agenda back up.
Sure. Okay. Thank you for having me.
Thank you.
Thank you.
Okay, so this is our open forum time. Does anybody have anything they want to present or other questions?
I have owner that's selling and the tenants have been great. They've only been there a year and we've already have offers on the house. Does anybody have anything coming up anywhere in Marietta, Wildomar, Temecula, Menifee? Like I said, they're excellent tenants. They take their shoes off in the house. I've never had issues with repairs or anything. I really need to find something for them. The lease is up February 28th and obviously we're going to close escrow right at 28th and then move in on the 1st. So
What's their price range and how many bedrooms do they need?
they need minimum, I think, is 3. They have 4 right now. And I think they're paying $2,200 right now, but they can go up a little bit.
Okay, because
I have homes.
Sandy, I have one coming up, should be available February 1st, we're hoping. It's a 3-bedroom over on Leafwood in Marietta off of Hancock.
Okay, all right, can you go ahead and just text me that information?
Sure.
Okay, thank you. And then that way,
I'll either call you or I'll send you an email.
Okay, perfect, either one, thank you.
So Sandy, I've got 3 coming up. They're all 3 bedrooms, all for 2,500. One's in Temecula, one's in Murrieta, and one is in Winchester. But it's very close to Murrieta, Temecula.
Okay, all right, thanks, Michelle. Yeah, I'll call you after, and then maybe you can give me a,
Okay.
I can let them know. Yeah, because their lease actually is end of February, comes up the 20th, so they will need to move the 28th or the 1st or something.
The Temecula one, they're vacating on the February 15th.
So then would that timeline work for you to get?
Yeah.
Okay, all right,
And that one's in Crown Hill.
all right. So I can talk to them about that. They both work in Temecula, so that might work better than the
Oh, okay.
Okay.
Yeah, that's a great house.
I got your message, Vicki. Thank you.
Okay.
Okay, anybody else have anything they want to bring forward? Our Walter was not able to make it, and basically the only thing he wanted to make sure that we knew about was that they are planning on extending the COVID laws until December 31st. Also, and it only matters slightly to our rental people, but he also brought up the fact that at federal level, they are talking about taking away the 1031 exchanges. So that may be something, as we get more information on that, that you will want to make sure your owners know about. It's just kind of hanging out there. It's something that Biden has mentioned. There's no details yet of how it would look.
Okay.
Other than that, our next meeting is February 10th, and we'll be on Zoom again.
I do have one more question.
Okay.
So I have a tenant that said that well, this is something else, that the heater wasn't working. So I went ahead and sent a handyman out there. Apparently they never changed the filter, it was clogged up. And so he said, you know, you have to change your filter. And then we'll know what's going on. So anyway, so they had other work to do. I texted the tenant, they said everything was fine after, but I guess the heater was still not working, which I did not know. So they complained again, and then I sent an HVAC guy out there, and I guess they reversed the enclosures, so it was sucking all their dog hair and sucking all the into the system rather than blowing it out of the system. So he said, and it blew part of the circuit board. So he said it looks like it's a tenant's fault. And so what in a case like this, I mean, they're fighting and they don't want to pay rent and things like that because they're saying we haven't had a heater for like 2 months and they've, you know, and all these issues. So what, I mean, any suggestions? I mean, should I just go ahead and just get it fixed and who cares? You know, or, you know, I told them that they're willing to pay half. Owner can pay half and they can pay half, but they're saying, no, it's not their fault.
Well, legally, you do have to provide heat,
Right.
not air, but heat. So you've got a problem there with not providing the heat. I would definitely, if they end up not paying their half, I would take it out of their security deposit, but that doesn't help you right now.
That's exactly what I was going to say. I get an invoice from the vendor stating the issue and whose fault it is.
Yeah.
And then I go ahead and get the repair done, but then I take it out of their deposit at the back end. And then they have to go file civil suit to get it back.
Okay.
But I've got all my ducks in a row.
Yeah.
All right. Okay.
I would agree
Thank
with
you.
that.
I appreciate it. Yeah, I have the HVAC guy scheduled for Saturday to fix the circuit board and everything. So we'll see if it goes.
Grant, did you have a question?
Oh, no, I was just saying, I agree completely with that approach as far as you've got to get it fixed now and make sure your invoice says what, you know, from the HVAC guy, what he thinks the cause of it is. And, you know, you're going to fight a losing battle trying to get them to pay until they get their deposit from it.
All right. Okay. Thank you.
Hey. Great meeting, guys. Thank you so much.
Thank you.
We will see you in February.
Thank you,
All right.
Deborah.
Thank you all.
All right.
Thanks,
bye-bye.
Debbie.
Thank
Have a
Okay,
good day,
bye.
everyone.
Yeah.